I just want to follow up on one thing that John was talking about, and that is the grandparent leave. As you know, the FMLA remains near and dear to my heart, and so I've given this a lot of thought, and I want to be sure everybody understands that that change is in some ways a lot more significant than it may even sound, because what it does is it puts us back in a situation where we now have different leaves available under state versus federal FMLA. So you remember we went through this many years ago with domestic partner. And what I mean by this is state FMLA now recognizes leave for grandparents, but federal does not. And so the practical effect of that is that if an employee, if you're covered by both state and federal FMLA, so that meaning you have more than 50 employees, your employee could now potentially, within a 1-year period, take up to 10 weeks of leave for leave because of their status as a grandparent, which will not run concurrently with federal because federal doesn't recognize that kind of leave, meaning that they could take potentially another 12 weeks of leave in the same 12-month or calendar year period. Okay, just want to be sure everybody's clear about that. And please amend your policies. They should already have been done because that went into effect on October 18. If you have not changed your state FMLA policy, please be sure you do that. Okay, so the ones that I'm going to be talking about, the first one is what we've been calling ban the box. And what it really is, when I first heard that, I thought it meant ban like the giant box stores. But that's not what it is. What it is the law that relates to asking for criminal record or conviction information from an applicant. And as you all know, for probably forever, you've had applications that have words something to the effect of, have you ever been convicted of a crime or a felony or a whatever you've called it, check yes or no. And some have spaces where you can explain it, some don't. I think probably everybody at this point knows that you cannot ask for arrest information at any point. It's only convictions, but that now has changed as well. And again, this change was effective October 18. If you have not updated your application, make sure you do that immediately, because what this law now says is that in order to remove obstacles that preclude applicants with criminal histories from gainful employment, you are no longer permitted to have that section, that box on your application. So it prohibits you from doing three things. One is, excuse me, requesting a criminal history record information on an initial employee application form, which is what I just said. Number two, stating on an initial employee application form or advertisement that a person with a criminal history may not apply, need not apply, or will not be considered for a position, or words to that effect. And three, you cannot specify in any other way prior to determining a person is qualified for the position that somebody with a criminal history will not be considered. So what that boils down to is you are no longer able to ask pre-conditional job offer about a criminal record history, although that's not completely correct either, because there are exemptions, there are exceptions to this, of course. Some of you are required to know about somebody's criminal record, conviction, or history or background. And so it says specifically in instances in which federal or state law, regulation, or rule mandates that a criminal conviction disqualifies an applicant from a position, imposes an obligation on an employer not to hire an applicant who's been convicted of a certain type of offense, or requires that you do a criminal history record check, this does not apply. So those of you who fall in that category need not worry about this. For everybody else, there are no longer any pre-conditional hire discussions. However, once you have determined that somebody, prospective applicant has been determined otherwise qualified for the position, or you are interviewing this person to make that determination, you may ask that question. So not on the application, but if you bring somebody in for an interview or you otherwise make a determination that you're going to be offering a conditional job, you may then make the inquiry. Except that you can't just say, have you ever been convicted of a crime? You have to then give the applicant the opportunity to explain the information and the circumstances regarding any convictions, including post-conviction rehab. So this concerns me because, as you know, I and others have been harping on you for the span of my 22-year career now here to not ask those questions in interviews or anywhere else. Because you may end up with protected information that you don't want and aren't supposed to have. But now that's changed. So if you want to know about somebody's criminal history, and of course you do, because you have other obligations like negligent hire and negligent retention, that really means you have to have that history. So you're not asking on an application, you bring somebody in for an interview, you may ask at that point, have you ever been convicted of a crime? And if they say yeah, if they say no, then you're done. If they say yes, then you have to give them an opportunity to explain so that you can then make an individualized determination about whether or not that really does have any impact on the job that you're hiring them to do. So as an example, if you work at a place where you have people drive for you as part of their job, but you are hiring this particular person as a receptionist, and in the interview you ask and you determine that that person has had an OUI conviction, maybe that you determine then that that's not directly relevant to the job that person's being hired to do because they're not a driver. And so maybe it doesn't automatically exclude them from being qualified for the job. So that's the determination you have to make. Where I get concerned about it is this phrase that's right in the statute that talks about giving them an opportunity to explain, including post-conviction rehab, because that's where you may end up with information about substance abuse, addiction, drugs, alcohol, whatever it is. In attempting to explain, the applicant says, well, yeah, I had a DUI. However, I went through this program. I went to an inpatient program. I'm following up with outpatient treatment, and I'm good now. I mean, in one way, that's terrific. In another way, that's not good, because now you have protected, confidential medical information, and if you determine not to hire that person, you're now at risk that the person will say, it's because now you know that I'm a recovering alcoholic or a recovering drug addict, and you didn't want to hire me because of that, not because of the conviction. So that's a little scary for me. But at any rate, that's what the law says, and that's what you have to do. So your tasks are review your application, make sure that it does what it doesn't do now, what it's not supposed to do. And I think it's important now that you be sure that if you are not the person doing the interviews, that you train whoever's doing them to make sure that they understand how this works. So if you have a supervisor or somebody who doesn't ordinarily interact that much with HR, doesn't have that training and experience, just make sure they know what kind of conversations they can and cannot have. And by the way, this does not preclude you. I don't see anything in here that precludes you from still doing the InforMe criminal background check, but now at a certain point. So after you extend the conditional job offer, but that's probably when you would have done it anyway, because you need date of birth to do that, and you can't have that until after the conditional job offer. So I don't think it's going to change that process at all. All right, so my next one is the Act to Improve Consistency in Terminology and within the Maine Human Rights Act. That is very badly worded. I don't know if I did that or not, but at any rate, so there were a few changes to the Maine Human Rights Act, 3 in particular that I'm going to talk about. The first is just a matter of terminology. And so the Act has long recognized that gender identity is a protected category, but it has subsumed gender identity within the broader term sexual orientation. And so now what they've done is they've broken out gender identity as a separate category. The commission itself has said this isn't creating any new rights. It doesn't mean anything that it didn't mean before. We're still protecting based on gender identity. It has the same definition. It's simply a matter of taking it out from under this umbrella of sexual orientation and making it its own thing. I think it's a matter of respect, basically, for people that fall within that category, not to be subsumed within a different category. So that's what it is. Gender identity is still protected, of course. So check your policies. You may want to now, in your EEOC statement or non-discrimination, you may want to separate that out as well. And along with that, the Act has added familial status in the list of protected categories. Now, familial status has existed before, and it was defined in terms of living with or caring for minor children. But there is a change to that. So it's been broadened now, and familial status now also includes people who are living with or caring for adults who lack the ability to meet essential requirements for physical health, safety, or self-care. Essentially, they're not adults who are not able to otherwise care for themselves. So that's now part of the Act as well, and you should make sure that that's added to your non-discrimination statement also. And then the last change that I want to talk about to the Maine Human Rights Act is they have added a provision for victims of domestic abuse who have sought and received an order of protection. It is now unlawful to discriminate against an applicant who falls within that category. And the purpose, of course, is to make sure that employers are not choosing not to hire people who are in that terrible situation and may need time off for various court actions or what have you, and maybe in bad circumstances. So you cannot discriminate on the basis of that either. Okay, so those were the two that I had listed, and then my next job is to sort of do a follow-up to any other legislation that we weren't able to get to. And so one of the things that I wanted to mention here is unemployment. So there were a bunch of changes to the unemployment provisions, and I keep hearing this buzzing. I think it might be in my head. I'm not sure, but at any rate, I don't know. So there are a bunch of unemployment updates. I know I've done them for a lot of you in these legislative sessions we've been having this fall. I'm only going to talk about one because I think the rest of them, you know, they impact you, but they're not overwhelming. But this one is significant. And so you know, there's a section in the unemployment statute under which an employee who voluntarily quits and ordinarily would therefore be excluded from being able to collect unemployment, there's a list of reasons why they might still be eligible for unemployment even though they quit. And they've now added to that list, and the new category, it basically says that a claimant may be eligible for unemployment benefits if the voluntary quit was due to the unexpected loss of a child or elder care, not loss of a child, loss of child or elder care, for which the claimant was not at fault and for which no work alternative such as changes in hours or a leave of absence or alternate child or elder care options were available, despite good faith efforts made by the claimant to resolve the issue and continue working. So there's a lot to that. So basically, what I think this was in response to COVID and all the problems people are having with lack of childcare, lack of elder care, and essentially is saying, if I have to quit my job because my childcare provider is no longer available, then I may be entitled to unemployment even though I quit. Except that you as the employer have some control over this, because it also says that not only do I not have to be at fault for this, but there can be no work alternatives available to me that I rejected. So if I come to you and say, my child care provider quit, not because my child is bad in any way, but just because she quit, and then meaning that I don't have anybody to watch my kids, so I can no longer work. If you as the employer say to me, oh, but I can help you out, I can give you remote work, or let's talk about changing your hours so that maybe your significant other can cover some periods, or you have somebody else who might be able to watch them. If you do that, and these are good faith efforts, and I reject them, then I think that gives you an argument why I would not be qualified for these benefits, okay? Because it says specifically that the claimant has to make good faith efforts to resolve the issue and continue working. So that's out there. And then I think that pretty much talks about most of the legislative updates. There are a few bills that are being held over. And I always hate to spend time talking about things that don't exist, because we have way more things that actually do exist to worry about, and we don't need anything else that might never come to fruition. But there are two in particular that I'm going to violate my rule because of. Well, actually, one is the most important, because there was a long fight about this legislative session, and it did not pass, or it was withdrawn, but it is going to come back, as I understand it. And that is that law that was going to treat vacation time differently upon cessation of employment. And so you may remember that the proposal was that despite your current vacation policies and any decisions that you've made about whether someone can carry it over or whether they're going to be paid out that time when they leave or any of those things, basically this would scrap any of your own policies and say, once they accrue it, they get it, no matter what your policy says, no matter what. And so I know Peter Gore and I did the seminar about it. We talked a lot about what this means and the financial impact on employers, which seemed huge. So it didn't pass, but it is, as I understand it, slated to come back. So just be aware, because you may need to mobilize again if you oppose that. And then the other one that we talked a lot about was the increase in overtime thresholds for what creates and what supports an exempt employee, because those were proposed to go up fairly substantially. That's been held over as well, so I expect that will come back. All right, so I have a few more minutes before we have break time, and I thought what I would do, so I was thinking while my colleagues were talking about leave, and I put together this little chart as I was sitting there. And I was thinking about the leave that I've been talking about earlier, and so I wanted to go through three categories that you are likely facing, and what leaves you might want to consider when you have one of these categories. So the first one is if you have an employee who's out because they have COVID, and I'm sure we'll talk more about this when we get to our COVID section, but you want to look at so this is somebody who actually has it, not a family member, not quarantined. You want to look at FMLA. You want to make sure you're looking at the EPL and whether they have leave available to use under that. And you want to potentially look at whether or not they're a person with a disability who may need leave as an additional accommodation under the ADA. But and I'm sure you probably know this, but the FFCRA no longer exists, right? That was done, even with the extension, that was done as of September 30. So you do not need to worry about applying, even voluntarily, the FFCRA. We may or may not see another version of it. That's entirely unclear. Now that kids can be vaccinated, it seems like that addresses at least part of the issue the FFCRA was created to deal with, and so maybe not. But at any rate, it's not in effect now. And this is not necessarily an exclusive list, but these were some thoughts, and we have a few minutes, so I'll go through them. Now, if it's not the employee, but it's the employee's family member who actually has it, all right, not that they're afraid of getting it, but they actually have it, and the employee wants leave for that reason. So once again, you go back to FMLA, right? Not because the employee has a serious health condition, but because they have a covered family member who has a serious health condition. And the provisions about needed to care for are extremely broad. So you want to look at that, and then you certainly want to look at the EPL and whether or not they have any time available under that. And then don't forget about the Maine Family Sick Leave Law. I mean, I know there's a million of these, and some of them get tossed by the wayside because there's too many. But the Maine Family Sick Leave Law, it's not new. It's been around forever and a day. I've never seen anybody bring a claim based on it, but it's there. And that's that law that says if you have 25 or more employees, then the employee can use whatever time they have, and however you qualify it or quantify it, whatever the word is, whatever you call it, PTO or sick or vacation, doesn't matter. They can use that time to care for a family member who is ill. So they don't define ill in the statute. It doesn't give anybody any additional time. It just says you can use the time that you already have to care for a family member. So you may want to make a note that you're running that as well, just so they know that you know that it's there. And then if the employee goes out to quarantine, not necessarily because they have COVID, but because they're just their kid has a close contact or whatever the case is. So somebody's quarantining. So we know no longer the FFCRA, right? Not FMLA because they don't have it. So they don't have a serious health condition. Not ADA, again, because there's no disability, all they're doing is quarantining. Not the Maine Family Sick Leave law because it's themselves and not a family member. But don't forget about the EPL, because now that the quarantining time can be unpaid, you don't want to fire somebody who's out because they have to quarantine, and you can offer remote work. But if that doesn't work out, you want to apply whatever accrued time they have, including the EPL. Okay. And don't forget that, of course, there's always a comp component to these, workers' comp. And so we've been dealing with that a lot, of course. I can talk at length about that when we get to the COVID section if we want to do that. It may apply. Most, if not all, the claims, at least outside the healthcare setting, are being denied as a matter of course, mostly because the burden of proving that it arose out of the employment and not somewhere else is just simply too great, I think. Although I do have one case working its way through the system with a very interesting twist, and we'll talk about that in the COVID section.